Following presentation will cover the following topic: the EU General Data Protection Regulation, or GDPR, and the impact on American colleges. What is it? The EU General Data Protection Regulation, or GDPR, is the most important change in data privacy regulation in 20 years. It replaces the Data Protection Directive 95/46/EC and was designed to harmonize data privacy laws across Europe, to protect and empower all EU citizens' data privacy, and to reshape the way organizations across the region approach data privacy. Regulation was approved by the EU Parliament on April 14, 2016, and took effect on May 25, 2018. To understand the regulation in all its aspects, you must first understand data privacy, which refers to the protection of sensitive information about individuals that is collected, processed, stored, and transferred by an entity. The Fair Information Practice Principles, or FIPS, are a set of internationally recognized principles that inform information privacy policies both within government and the private sector. The FIPS are made up of core elements consistent among nations, states, and economic sectors. These core elements are incorporated in data privacy laws, policies, and governance documents all around the world. The following formulation of the Fair Information Practice Principles is used by the Department of Homeland Security. Purpose specification. Agencies should specifically articulate the authority that permits the collection of personally identifiable information, or PII. The purposes for which PII is collected should be specified at the time of data collection. Subsequent use of this data should be limited to the original purpose for which the PII was collected, or other purposes compatible with the original collection purpose. Data quality or integrity. PII collected should be relevant to the purposes identified for its use and should be accurate, complete, and up to date. Collection limitation or data minimization. PII should be collected only if the data is directly relevant and necessary to accomplish the specified purpose. PII should be obtained by lawful and fair means and retained only as long as is necessary to fulfill the specified purpose. Use limitation. PII should not be disclosed, made available, or otherwise used for purposes other than those specified, except with the consent of the individual or by the authority of law. Security or safeguards. Agencies should institute reasonable security safeguards to protect PII against loss, unauthorized access, destruction, misuse, modification, or disclosure. Accountability or audit. Agency personnel and contractors are accountable for complying with measures implementing the FIPS, for providing training to all employees and contractors who use PII, and for auditing the actual use and storage of PII. Openness or transparency. To the extent feasible, agencies should be open about developments, practices, and policies with respect to the collection, use, dissemination, and maintenance of PII. Agencies should publish information about policies in this area, including the PCRCL policy. How are FIPS used in the U.S.? They are sector-specific data protection. For example, there is HIPAA for medical, FERPA for education, FTC, privacy and data safeguarding rules for commercial and credit transactions. There's COPA for children, etc. Additionally, many laws regulate only part of the data lifecycle, including collection, processing, use, retention, transfer, disclosure, and deletion. With all this in mind, what is the goal of the EU GDPR? Since 1995, the world has become increasingly data-driven. There are still relevant data privacy principles. However, much has changed since the 1995 directive. The aim of the GDPR is to protect all EU citizens from privacy and data breaches. Key changes in this regulation include the following. Breach notification. Under the GDPR, breach notification will become mandatory in all member states where a data breach is likely to result in a risk for the rights and freedoms of individuals. The notification must be done within 72 hours of first having become aware of the breach. Data processors will also be required to notify their customers, the controllers, without undue delay, after first becoming aware of a data breach. Right to access. As part of the expanded rights of data subjects under GDPR is the right for data subjects to obtain from the data controller confirmation as to whether or not personal data concerning them is being processed, where, and for what purpose. Additionally, the controller must provide a copy of the personal data free of charge in an electronic format. This change in policy is promoting data transparency and empowerment of data subjects. The right to be forgotten. This is also known as data erasure. The right to be forgotten entitles the data subject to have the data controller erase his or her personal data, to cease further dissemination of the data, and to potentially have third parties stop processing the data. The conditions for erasure include the data no longer being relevant to original purposes for processing or a data subject's withdrawing consent. This right requires controllers to compare the subject's rights to the public interest in the availability of the data when considering such requests. Data portability. The regulation introduces data portability or the right for a data subject to receive personal data concerning them, which they have previously provided in a commonly used and machine-readable format, and have the right to transmit that data to another controller. Privacy by design. Privacy by design calls for the inclusion of data protection from the onset of the designing of systems rather than an addition. More specifically, the controller shall implement appropriate technical and organizational measures in an effective way in order to meet the requirements of this regulation and protect the rights of data subjects. Data protection officers. Under GDPR, it will not be necessary to submit notifications or registrations to each local data protection agency of data processing activities, nor will it be a requirement to notify or obtain approval for transfers based on the Model Contract Clauses, or MCCs. Instead, there will be internal record-keeping requirements and data protection officers appointed, which will be mandatory only for those controllers and processors whose core activities consist of processing operations which require regular and systematic monitoring of data subject on a large scale or special categories of data or data relating to criminal convictions and offenses. What does GDPR mean for American colleges? A German student uses a college's website to apply for admission. An alumnus who lives in Italy can make an online donation. A faculty member who spends a sabbatical in France and communicates with colleagues back home. These are examples of how EU students, faculty, and other constituents of an educational institution can fall under the jurisdiction of GDPR. The EU's General Data Protection Regulation will impact any organization worldwide, including US colleges and universities that process data relating to people in Europe. One big problem. Various experts believe American colleges are not prepared and could face heavy fines as a result of this. Failure to comply with new rules could cost US institutions more than $23 million in fines. However, very few colleges appear to be prepared. The new rules will require institutions to take extra steps to protect the personal information of people in the EU, regardless of whether they are EU citizens or permanent residents. Additionally, the requirements would also apply to American students or faculty members who communicate with campuses while they are in Europe. In addition to understanding what data they hold, where the data is stored, and how they are used, institutions will need to be able to accommodate requests to retrieve, correct, or erase the data. They must also promptly report any data breaches. A common misconception stated by Julia Funaki, Associate Director of International Education Services at the American Association of Collegiate Registrars and Admissions Officers, is that institutions are already doing enough because they meet the requirements of the Family Educational Rights and Privacy Act, or FERPA. But the requirements of GDPR and FERPA are vastly different. One differing feature of GDPR is the right to be forgotten, said Funaki. The rule could lead to demands to find and eliminate email records, addresses in alumni directories, admissions applications, and more. So this question lies: how can American colleges become GDPR compliant? Since GDPR is not just one person's responsibility, institutional coordination and collaboration is going to be key, especially from the top down. You need to bring people together who handle student records, offer legal counsel, buy services from third-party vendors, and those who handle IT security. Institutions should hire staff to work on GDPR. However, there is a major barrier in terms of no specific firm or technology companies having emerged as the go-to experts yet. Institutions should work through different scenarios for their different constituents to look at different options of what they should do in different situations. They need to dive deep into the regulation and get a strong understanding of what will be needed. Institutions should identify all third-party vendors working with them and check to make sure they are all also compliant. GDPR should be seen as an opportunity to employ better data management, better governance, and better data hygiene. I'll leave you with a quote from Julia Funaki. In Europe, privacy is considered a fundamental human right, but in the US, we tend to think of it as a consumer right, said Funaki. She added, I think this is just the beginning of a long conversation about data protection around the world.